Welcome, fans of freedom in the world and supporters of Project Censored and the ACLU and Amnesty International, and for the success of the federal lawsuit against the Dickinson, North Dakota police torturing machine who compelled false confessions out of the Dickinson Trinity principle. Yes, that this will just not end in a dungeon and lies in Dickinson, North Dakota. And thank you to the over 93,000 visitors we have had here at www.searchworldnews.com. Yes, here we are in the evening of June 19th, 2015, and it is Friday night at 10:27, and here we have court documents, yesterday's. This is from Jonathan Byers, Assistant Attorney General. The motion to dismiss comes now the state of North Dakota, and he does hereby move to dismiss the remaining two counts for the reasons listed in the accompanying brief dated Bismarck, North Dakota, this 18th day of June, 2015, State of North Dakota, Wayne Stanton, Attorney General, by Jonathan Byers, Assistant Attorney General, and I believe this was signed for Mr. Byers, Mr. Emerson, perhaps, for, yes, it's signed for. It doesn't seem the news media is getting a hold of Mr. Byers very easily recently. Okay, here is the brief in support of the motion to dismiss. On June 4, 2015, the court issued its order for mistrial, indicating that the defendant could be retried, but only on 2 of the 5 counts he faced in the first trial. On June 8, 2015, the state received a notice of hearing setting the case for trial as the lead-up case on June 23, 2015. 2. The state filed a motion for continuance on June 8th, which was denied by the court on June 12, 2015. One of the reasons cited for denying the continuance was the defendant's speedy trial rights, which he has never asserted. A request for speedy trial must be filed within 14 days following the arraignment, which in this case was held on September 5, 2014, according to North Dakota Century Code 29-1902. 3. Another reason cited for denial of the continuance was that the state had not yet even requested a transcript. Until the court issued the June 4 order, there was no reason to spend taxpayer dollars to prepare a transcript of the trial, which lasted longer than a week. Mr. Hoy's reply asserts that the state should have anticipated a mistrial, but neglects to mention that the court was also considering his renewed motion for a judgment of acquittal. This was filed June 18th, 2015 at 4:44 and 2 seconds p.m. Cass County, the Clerk of Court. Page 2, paragraph 4. This is being recorded for searchworldnews.com, and this is the opinion site for LA Civil Rights News Group, registered media group of Fargo, North Dakota, registered in the North Dakota Secretary of State's office. Here we are, page 2, paragraph 4. The court cites, quote, prejudice to defendant, end quote, as another reason for denying a continuance, including anxiety and concern as well as deprivation of employment. The court repeats Knodel's argument that the case has been pending since August of 2014, and state has been investigating the matter since February of 2014. This impliedly makes the suggestion that the state is somehow responsible for the length of time the case has gone unresolved. The case was originally set for trial on December 16, 2014. At Mr. Hoy's urging, the parties entered into a stipulation rescheduling the case for March 24, 2015 trial date. The second paragraph of the stipulation states, quote, The state should be set for trial on a date certain, giving the party sufficient time to investigate and prepare for trial, end quote. Paragraph 5. Shortly before the March trial date, Knodel filed an objection to the state's handwriting expert, which caused the state to have to enlist the services of an expert from out of state. Knodel then claimed that 2 weeks was not sufficient notice of the new expert, and that the expert testimony should be excluded, or, in the alternative, a continuance granted. Pursuant to that request, the trial was rescheduled to April 21. Paragraph 6. The state was diligent in its preparation for the April trial date. All witnesses were called and presented in a timely manner. The state was not in any way responsible for the mistrial that occurred. Beverage sipping before we go to paragraph 7. Paragraph 7. Following the mistrial, it was important to take the time to reflect on the available options and the need to, quote, do the right thing, end quote. Neither of the prosecutors involved have ever had a win-at-all-costs mentality. Despite the briefing schedule already set by the court and the need to preserve all rights while reflecting on what the, quote, right thing, end quote, was, I think it's fair to say that both of us have always been leaning towards accepting the will of the jurors that remained to the conclusion of the trial. End of page 2. On to page 3. This beautiful artwork on searchworldnews.com is that of the North Dakota Attorney General Wayne Stenjum. And here we are poking fun at well, there's only so much fun to be poked here, because, in our opinion, what this case was partially brought for was to take the public's minds off the student murders condoned by the police. And North Dakota being the home, here's the more humorous part, North Dakota educated law firm of Stenjum, Fatz, and Rack. Well, Stenjum is identified as Stenjum. Fatz is identified as one of the prosecutors who is the largest among them. And Rack, or North Dakota Attorney General Wayne Stenjum's best prosecutors. Go figure. They got into North Dakota Law School, one of the top 700 law school in the Northern Plains. Yes, there is Fatz. Here is Fatz of the North Dakota law firm of Stenjum, Fatz, and Rack. They all hate attractive males who succeed through hard work in any field. Their law degree did not get them laid by quality females, nor did their constant win at any cost arguing. Here, I guess we diverge from the statement that they never had a win-at-all-costs mentality, nor did their constant win at any cost arguing law or justice. They could care less if innocent persons are intimidated to guilty pleas by corrupt, giglio, impaired cops like Steve Kukowski or Dickinson's Kylan Ladyboy, well, quote, Ladyboy, end quote, Clouser. 40 years for a couple of joints. We changed our mind. We will have corrupt, drug-selling cops shoot you dead. This is the reference to the death of Mr. Andrew Sadek and his dumping of his body weighed down by rocks in a backpack dumped on the Minnesota side of the border. Not too much investigating by the North Dakota cops. We are digressing here. Where is the rib steak sale this week? Which Fargo buffet has the freshest cheap food? I don't understand why some guys like girls. Not when there is food. My bestest friend. Guess we should not have helped killed Maggie's dad. But fuck. Now Hoy can't question him about little Maggie Blueberg. I'm hungry. And here is Drac. You may simply go to searchworldnews.com. Yes. And our opinion is thereby recorded therein But now we return to the state's brief for dismissal dated June 18th, 2015. Paragraph 8, page 3. Despite this inclination and likely result, the events that have occurred since the mistrial have made us feel like cattle in a chute being driven towards a foregone conclusion at the point of a sharp stick. Mr. Hoy's cognitive distortions about Knodel's willingness to accept a verdict of less than 12, to his insistence on trying the case in the media, have caused more pause than forward movement towards accepting the jury's will. The belief that a prosecutor's discretion should be determined by public referendum caused more pause than forward movement, especially when the letter-writing campaign outlines, quote, how to write the Attorney General and ask him not to request a mistrial, end quote, rather than simply to express your views one way or the other. Paragraph 9. The court's decision to put in a document sure to be quoted by the media and sure to be seen or read by any future jury panel that, quote, thus, well, the state's evidence in this case was weak, and while the defense presented strong evidence and argument that Mr. Knodel did not commit the acts for which he stands accused, end quote, was a decision that caused great pause and a need to reflect on the true nature of fundamental fairness and interests of justice, to set this case for retrial in just over 2 weeks without any consultation with the parties about their prior scheduling makes the stick seem very sharp indeed. 10. Paragraph. Nowhere in the court's order is there a mention of the anxiety and concern of the victim. The young woman in this case has been treated horribly unfairly by the letter-writing campaign and online bloggers. We digress. If we are being referred to as an online blogger, we herefore declare that we are the only media in the state of North Dakota that aggressively opposes public corruption. The only media in the state that aggressively cannot stand public corruption. And there's a lot of it here in North Dakota. Here, our friends are Stenjum Fatsendrack is saying, another case of Oreos. We have here, in the humorous props of LA Severoid News Group, as we read this motion for dismissal, have at hand, from Cashwise Food, Oreos. 3 of these wonderful packages, to include a lemon package that has already been downed in honor of the, who is it? The anxiety of the young woman in the case. Oh, yes. So we have the Oreos here, and Fats on the leading media site for opposing public corruption. Another case of Oreos. I think I'll name you Maggie. Chomp, chomp. Just one more brief before I sleep. Drac, have an Oreo. I named them. If a person is innocent, I'll argue that they are guilty. Good for me. This is simply humor in addition to our wonderful opinions. Yay. Okay. What's happening here? Back we go. Nowhere in the court's order is there any mention, this is 10 again, nowhere in the court's order is there a mention of the anxiety and concern of the victim. Victim. Well, we submit that now that the jury has found and stated in an affidavit of the jury foreman, henceforth known as the jury foreperson of the jury, the foreperson of the jury rather than, yes, you get the picture. Anyway, she states that the jury believes that he is not only not guilty, but innocent. Innocent. The young woman in the case has been treated horribly unfairly by the letter-writing campaign and online bloggers. Some of the views being expressed in the letters and to the media have set the cause of sexual abuse reporting back 3 decades. Our young people watch all of this and quietly take it all in. Is that referring... They're quietly observing the Oreos and taking them all in? This doesn't really make a whole lot of sense, except being a provocative statement as to why the state, perhaps, is not going after murderers of students in the state and torturing of educators to include, in our opinion, Mr. Aaron Knodel himself, and that there has been a complete turnabout in the view of society as to who the victim in this case is. There has been a complete flip-flop, 180 degrees as to who the victim is. And that victim, we would say, is not the young woman in the case. No, the victim is Mr. Knodel and his wife and his family and their parents, educators, targeted. Targeted as to what? Their retirement accounts to pay legal fees? Exactly. How was this done? I mean, now, Dr. Norberg with his beautiful wife Alona, yes, money. Money. Thank goodness that there's some money here, because without a criminal defense attorney like Mr. Hoy, our opinion says, you're just screwed, you're fucked, you're gone. Yeah. Okay. Our young people watch all this and quietly take it in. 11. Despite the unneeded prodding, the people's lawyers still believe in doing the right thing. We request a dismissal without prejudice, absent new evidence. The case, to page 4, will never be recharged. The court should not dismiss a case with prejudice unless the court has had an opportunity to determine issues of bad faith, harassment. Talk to us, Mr. Principal. You already confessed. We know you set your school on fire. No, you cannot have food or water or light in your cell. You just take some time to think about it. You already confessed. Or misconduct. State v. Graff. Volume 484 Northwest Reporter, second edition, at page 855, and North Dakota Reports 1992. Knodel will be able to raise those issues should the need ever arise at the appropriate time, dated this 18th day of June 2015. State of North Dakota, Wayne Stenjum, Attorney General, by Jonathan R. Byers, number 04583. Mr. Byers signs off personally on this one. Assistant Attorney General, Office of the Attorney General, 600 East Boulevard Avenue, Department 125, Bismarck, North Dakota, 585-540-713282210. J. Byers at northdakota.gov. Attorneys for the plaintiff. Very nice. Very nice. A brief in support of the motion to dismiss. Hey, here in our channel, searchworldnews.com, we have canned heat, sick 'em pigs. Let's see if we can get the sound going to sick 'em pigs. Yeah. Complete with pig squealing. Pigs on you. Go downtown, but don't you run around. What would you say? Play the game that way. Stick the pigs on you. City Hall, they're gonna get you too. Sick the freaks on you. Oh yeah, this can be your school song in your elementary and middle school and high school in North Dakota. Back to the territory for this protection.
The way to serve God and country. Chances come. We are now recruiting trainees for the Los Angeles County Sheriff's Department.
Yeah.
If you are big, strong, and stupid, please call 626.
Maybe the citizen should hang themselves if they have questions. Oh, look what happened to this guy. He had questions too. Okay, babies. That's the state's position in our opinion. And now, my friends, we will go on to the answer of Hoy, Bunsen, Twitchell, defense attorneys. Thank you for watching. 93,000 visitors. This cannot happen again. Ka.